All right, calls number 23129-303 and 23129-304.
Appreciate it. Aren't you going to take a seat?
No, I'd rather stand.
Well, it's your hearing, sir.
Is it okay if I stand? Is there something wrong?
Why do you have to stand so close to him?
The sign there that says no standing.
Oh, well, okay. I just know I was subject to those rules. I didn't agree to it. Anyway.
Okay, so there's a bench warrant.
You know, I'm just going to take the seat.
Thank you.
Sit right here if that makes us a little more comfortable.
Is it uncomfortable if I stand up, Your Honor?
Well, depends on how you're going to act or behave today.
I'll have a seat.
Okay, so you failed to appear for court multiple times in this case.
Your Honor, just for the record, the named defendant is actual property, a registered trade name.
Oh, here we go.
And the case has also been certified as a fraud. I have court certified documents to prove that. That should be on the record, and that's the reason why it was certified.
All right, guys, today's case is not just strange, it's completely unreal. You're about to watch a man walk into court and deny reality itself. Not guilty? No. He claims he's not even the person on trial. According to him, the defendant is just a piece of paper. Yeah, you heard that right. A literal piece of paper. And somehow, he believes that excuses everything. The courtroom freezes for a second, trying to process this madness. But the judge? Calm, focused, not impressed. Because this isn't his first time dealing with chaos like this.
So, on the 9304, I am going to quash that one. He was in Ralch appeal status, and so I'm going to quash that one. But I do want to hear from the state on the 303 matter.
Yes, on the 303 matter, Mr. Haywood was sentenced to serve 4 days in jail. He failed to report to the jail on June 29, 2023, and we're asking him to be taken into custody to serve that time.
Object.
The moment the hearing starts, he goes all in. No hesitation, no filter, just pure confidence. He claims the court is a fraud, says the state is a foreign corporation with no authority over him. According to him, laws don't apply, rules don't matter. He's operating on his own version of reality. And to make it worse, he keeps interrupting nonstop. Every sentence turns into another wild argument. But the judge? He's already seen through it all.
The 303 he was convicted and ordered to do jail, and you believe that he didn't comply with jail because there's a docket entry that said defendant complied with jail. Maybe that was an error.
That was probably my attempt to deliver the defendant to the jail, but they refused.
And we relooked that he had not, as was the state's actually, that he had not served the jail time.
And just to clarify, the defendant only exists on paper, just as the plaintiff only exists on paper. The jail refused the paper, and here we are today. And the state still hasn't proven standing yet, by the way, as well.
Now things start getting serious. Because this isn't just talk anymore. There are consequences. The judge lays out the facts clearly. Missed court dates, active warrants. This isn't theory. This is documented behavior. But instead of responding logically, the man doubles down. He claims he tried to turn himself in as paper. Yes, paper, not a person. Even the courtroom can't ignore how ridiculous it sounds. And now the judge begins tightening control.
Under penalty of perjury that I am the defendant. And I've uploaded plenty of documentation to prove I'm not the actual defendant. That is a registered trade name, matter of public record, and registered with the state. So if you want me to serve some jail time, then we're going to need to change who the defendant is, because I'm not the defendant.
All right, so can you upload a new commitment?
Yes, Your Honor.
And the reason they couldn't put my name on there as a defendant is because I'm a foreign sovereign with respect to the corporate entity known as the state of Washington, of which I have no contract with.
Wow! The land of make-believe!
Okay, so with respect to the...
This is where the tone shifts completely. The judge stops entertaining the nonsense. No more back and forth, just firm authority. He explains the situation in plain, undeniable terms. You were ordered to serve jail time and you didn't. Simple, direct, no loopholes. But still, the man refuses to accept reality. He keeps repeating the same broken arguments, and that patience, it's starting to run out.
Challenge, it must be established on the record. And it hasn't been, and it still isn't. You can do it now if you like, if you can.
Okay, so, Mr. Haywood, you failed to appear many times in both of these matters, had many warrants quashed. And, to be perfectly honest, I'm not confident that you're gonna come back to court, given the history of failing to appear.
I will agree to come back to court on behalf of the appearance fiasco was simply because the communication between the acting prosecutor at the time and myself. I have plenty of emails. So in one case, he said he was just going to reschedule with the judge. I told him, reschedule whenever you want. I'll go ahead and be there, and I'll bring the defendant with me.
Now comes the most unbelievable part. He insists again he is not the defendant. That name? Just a registered trade entity. The real him? Somehow separate. Untouchable. It's a tactic often seen, but rarely this extreme, and the judge shuts it down instantly. Because in a real courtroom, facts beat fantasy, no matter how confident the delivery is. And right now, that fantasy is crumbling fast.
For the defendant to be here. I am simply bringing the defendant to the court to help try to solve the problem. The fact that the registered trade name remains as a named defendant is an act of identity theft and fraud, and that's probably why the state has acquiesced that the case is a fraud. I have the documentation here with me today in case if they decided not to upload it to the court record.
Well, you had your day in court on the 303 matter. You had a trial. You represented yourself. Or the defendant, whichever way you want to say it, but you represented the defendant yourself, and you were convicted, and you were ordered to serve 4 days in jail. You didn't do that. And so
The judge now looks at the full picture. Multiple failures to appear, repeated defiance. This isn't confusion. It's a pattern, a dangerous one. So he makes it clear this won't continue. You either follow the law or face the consequences. No more games. No more word tricks. And suddenly, the situation turns serious because custody is now on the table.
that time, I'm going to serve the warrant, and so we need a pretrial date, Madam Clerk.
There's no jurisdiction yet been proven or standing. Are we going to continue? That would be an act of fraud and treason.
Your Honor,
That's a felony. That's an arrestable offense.
I put both of them in one of 4 hours.
Well, we don't need anything on the 303. He's just going to serve a sentence.
Okay.
We just need the 304, and
Yes, I
I
have
see
the
that
defendant here with me today. You can take him
it's
to
going to be September 13th. We probably need to change that since I'm taking him into custody. So do we have anything in August?
Excuse me, Your Honor, are you testifying that I am the defendant under penalties of perjury?
I'm not testifying to anything.
Good. Here's the defendant right here.
All right.
Your Honor, we can do August 24th at 10:30.
All right, I can change.
Even at this point, he doesn't stop. Still arguing. Still denying jurisdiction. Still acting like none of this applies to him. But here's the reality. The court has already decided. The judge warns him clearly. Sit down, or things escalate. But instead of listening, he pushes further. That's the moment everything snaps. Because the courtroom isn't a debate stage. It's a place where decisions are enforced.
10:30 in the morning. If you change your mind about representing yourself, then you can ask for help if you want it. If you don't want help, we don't have to have it. So we'll see you in August. I'm going to have you take a seat right over there.
We'll be here for the defendant on August 34th. Would you like me to deliver the defendant to the jail?
I would like you to sit over there
Is there any standing
with the
or
defendant.
jurisdiction chosen, proven here yet?
Please go take a seat.
Okay, so let the record reflect no jurisdiction has been proven, and neither has the identity of the defendant definitively been established.
Okay, please go take a seat. Sonia Sesko, customer 231024002. Mr. Haywood, sit down.
Am I obligated to follow these rules?
You are going to sit down right now.
Do you have any jurisdiction? I don't believe you have any jurisdiction that's been proven yet.
Please sit down.
Are you threatening me with violence?
I'm asking you to sit down.
You don't have authority over the defendant. He has no authority.
And just like that, it's over. The judge orders him into custody. No more arguments. No more interruptions. The system he denied, now fully in control. He's told clearly, leave, and it becomes a felony escape. For the first time, reality hits, the tone changes, the energy shifts, because this isn't theory anymore, it's consequences. And in the end, the same authority he rejected wins.
Best interest in the best interest of peace. In regards to your violence, I will go ahead and relax for a minute, but let's get with it. I got things to do. Got it?
What was that just thrown?
Car keys.
Do you know that person?
Yeah, my voice.
Okay. All right. So thank you. Mr. Haywood has been very disruptive. He tried to leave the courtroom once he was placed in custody. So just FYI, be careful with him.
So, give me a break. Can I just see just need to see it, thank you. Can I see who's being put into custody, please? I just need to see the name. I just need to see the name of the person. Okay, that's not me, that's the problem.
Sanborn's matter, we're here today on.
No, that's not me. The name is saying, but that's my registered trade name. I got all that documentation right here.
Okay.
You want it? Okay. Yeah. This is the defendant, technically.
If you want that, I can still put everything present.
Hold on 1 second. That's taken care of.
We can see this thing and get right in.
Did she file a notice of appearance?
I will make sure that she does, Your Honor.
Okay. Yeah, sorry, I haven't had enough coffee yet today. So yeah, no, you've got Ms. Bradshaw, so that's fine. You don't need to do those forms. But she does need to